You're ready to begin the journey of selling products online. So exciting. Having that extra little bit of revenue hit your bank account on the side is a great way to go about doing business. But I want to make sure that you're selling products online legally. Hi there and welcome back. If you're new here, my name is Paige. I am the owner and lead attorney behind The Legal Paige. I help small businesses get legally legit in no time without breaking into hives. If easy and simple legal tips are just what you need, please subscribe to my channel. Now, before you reap any of the benefits of the digital passive income space, and trust me, there are plenty, there are some big legal considerations that you need to know about. So here are 5 steps to ensure that you are legally protected when you sell products online. Step number 1 is legally adding people to your email list. Of course, you want to build an email list so that you can market your digital product. But is your opt-in set up correctly? So as you're building your email list, you're probably offering some type of freebie or lead magnet for people to sign up and enter their first and last name and email address to get something free from you in return. And then they get to be on your email list. But before they get on your email list and before they hit that submit button, you want to ensure that you have a proper legal disclaimer on this pop-up or landing page when you ask for their personal information. I'm sure you're wondering what needs to be in this legal disclaimer. It can be really short and sweet. They don't have to check the box or say I agree or any of those things. You just want to put the person on notice that in return for them pressing the submit button and giving you their personal information, that they agree to receive marketing and advertising materials from your company. Usually this is in the form of adding them to a newsletter list. And then when they're on the list, you have to allow the users a way to unsubscribe if they no longer want to receive those marketing newsletters from you or any type of marketing emails or blast that you're sending out. Remember, it's against the law to keep people permanently on your email list. There has to be a way out. Step number 2 is you need terms and conditions on your website and a privacy policy. Every business owner needs terms and conditions. Although not required by law to have them, it is a great thing, especially if you're selling digital products online, to include website terms and conditions on the bottom footer of your website. So I'm going to be talking about website terms and conditions here, a privacy policy, and a product purchase and use agreement. We're going to start with website terms and conditions. So website terms and conditions are there for any users on your site to know how to interact with your site, what your business policies are, copyright and intellectual property information regarding things they find on your site, including copy and imagery. Of course, you're going to restate any type of return policies or exchange policies and express any warranties or disclaimers that you need to. And then to briefly talk about privacy policies, this is incredibly important in the United States and virtually worldwide because of personal privacy protections. As many of us know as business owners, privacy laws have gotten more and more stringent. And so you need to ensure that in that bottom footer, you have a privacy policy. This is going to be separate than your website terms and conditions. And it's going to really explain the who, what, when, where, why, and how. So who is taking the person's personal information? Your company. Where are they taking it, putting it on their newsletter list? Why are they doing so for marketing and advertising purposes? And then how can they unsubscribe or get rid of their personal information off your list? And then really where to contact you to do so. Of course, if you're interacting with any type of customers that may be a part of the European Union, you want to also ensure that you're abiding by the GDPR and putting that in your privacy policy as well. Now, quickly going back to step 1, because step 1 and step 2 interact with one another. On your pop-up, if you want to link in that little disclaimer, here are our website terms and conditions and privacy policy, you can link both of those there on your opt-in pop-up or your landing page. Now I'm going to pause here and not talk about digital product purchase and use agreements. I'm going to talk about that in step 4, so stick with me in this video. So step number 3 is to abide by social media rules and FTC rules. This is really important for people who are selling products online whereby they have affiliates or ambassadors promoting their products. If that's you, then listen up. The FTC, Federal Trade Commission, sets very, very particular rules and regulations surrounding what your affiliates and ambassadors have to do when they promote online. Most of us know this through social media marketing, and so we oftentimes see different ads popping up or in Instagram stories popping up with affiliates doing links and putting sponsored and all of those things. How do you do it correctly? Well, the good news is I first have a blog post that will give you all of the information in the description of this video. Legally speaking, your company needs to sign some type of affiliate agreement with them or ambassador agreement with them. And within those agreements, you want to ensure that it's the affiliate or ambassador's responsibility to post according to the FTC regulations. Usually, it's just making sure that it's not deceitful or confusing for a consumer, and that the affiliate is making sure that if it's sponsored, if it's a sponsored post, that they have hashtag sponsored, or they put sponsored somewhere on the video, as well as if it's an advertisement or an affiliate link, that they just need to adequately disclose that when posting about your company and digital products. Again, I just want to reiterate here to make sure that you are not going to get in trouble. You want to make sure that your affiliate and ambassador sign an agreement that is their responsibility to post according to FTC rules and regulations. Speaking of contracts, step number 4 is to ensure that you have all of your contracts in place to sell online products. And I want to go through 3 here with you today. So the first is a product purchase and use agreement. Especially if you're selling digital products, you want your customers to agree to the terms and conditions of them buying said digital product before they actually check out. So how do you do this? Most e-commerce platforms and softwares allow you to have terms and conditions either in a box that your customers can scroll, or you can link your product purchase and use agreement right there. Now, the important thing is to voluntarily make sure that your customers are agreeing to these terms and conditions. So in the checkout process, where you have that the customer would agree to your product purchase and use agreement, you can either have them type in "I agree" or check a box voluntarily indicating that they do agree to the product purchase and use terms for your company. The biggest thing I see legally is that people who are selling digital products online are not conspicuously disclosing their terms and conditions related to the digital product. Most digital products are non-refundable because of the instantaneous receipt from your customer once they make the transaction. It's probably an automated process online where that digital product is sent immediately to their email. And as the company, there's no way to know once they get that email what they do with it. They have access to it, they can use it, they can download it, they can print it. So a no return policy is very common for digital products in that respect. This type of thing would be in a provision in your digital product purchase and use agreement, as well as other clauses related to copyright infringement and that you are still the owner of the copyright of your ebook or your digital product that you're selling. I also want to inform you about online course agreements. So if you're selling a digital product online that is an online course, that's different than just a singular digital product that goes directly to somebody's email address. An online course is going to need an online course agreement. That's different than a digital product purchase and use agreement. Same thing goes at checkout, where you're probably going to want to put this online course agreement either linked or in a little box that people can scroll and read your terms and conditions for them purchasing the online course. And in this agreement are going to be things related to chargebacks and refund requests, payment plans. Lots of online courses are expensive, so they have payment or installment plans. You want to explain your policies on that and automating credit card charges. Of course, communicating with your company outside of the course if there's any forums or group communication places for your students. And of course, copyright ownership as well would be in this agreement. And then finally, if you're selling a digital product by way of a membership, then you want to make sure that your customers are signing a membership agreement. So a membership program is very similar to a subscription that we all know about: Netflix, Hulu, Apple TV, that we all get charged automatically per month. And we do agree to terms and conditions when we're signing up with these companies. So you want to have a very, very similar member program agreement in place. The membership agreement really needs to go over what the payment is that they make when they sign up. Usually it's for their first month dues, and then that they will automatically be charged if they don't give you sufficient notice to cancel. So you want to have notice provisions in this agreement surrounding when they need to contact your company or when they need to submit their cancellation request so that they don't get charged the next month. Of course, in here, you're going to have similar things such as chargebacks, refund requests, any type of bonus structure that you give people at certain times of the year when they sign up for your membership program, that it's only available during those times and it's not backdated. And of course, copyright intellectual clauses as well would be in this agreement. And step number 5, to legally protect your digital products that you're selling online, is to have trademark and copyright protection of your intellectual property. So let's start with trademarks. Trademarks are any business name, brand name, sub-brand name, or a slogan. If you have a unique business name, unique digital product name, unique online course name, unique membership program name, you absolutely need to register for a federal trademark. This is because in the online space, your name, that trademarked name, is out there for the world to see. And so protecting it, especially within the confines of our nation, the United States, federal trademark protection is a good first place to start because most of your purchasers will probably be in the United States. Remember, your trademarked name is now blasted on your website. It is all over online and worldwide people can see it. So national protection through a trademark registration is key here to ensure that your name doesn't get taken. How do you file a trademark registration? My best answer, go find yourself a trademark attorney. It's going to save you time, energy, confusion. The United States Patent and Trademark Office online filing platform is very archaic and very confusing, so it's best to just hire an attorney to do this for you that has experience. Usually this can cost anywhere from about $1,000 to $2,000. Remember, it's a professional expense on your business. You can fully write that amount off, and it's going to save you, I can promise you, thousands down the line from any type of infringement issue that could occur. If you want to protect your brand name or your slogan or your digital product name, make sure you go get it trademarked. So what's the difference between trademarking and copywriting? So anything that is fixed in a tangible medium, such as a PDF or online course slides, those would be copyrightable. If you're a photographer, an artist, a videographer, calligrapher, you know how essential you having ownership in your copyrighted works is. What most people don't know is that you don't have to register your copyrighted work in order for you to have rights. You have common law rights in your copyrighted work the minute it is fixed in a tangible medium. So the minute you create that PDF on Canva, the minute you click the shutter on your camera, all of those works are automatically copyrighted by you. But once your online course starts getting lots of traction or your digital product is getting a lot of sales, you're probably worried about someone stealing your entire process. And that is where you would want to register that work with the US Copyright Office. Registering your work is key to getting more damages. You have common law rights of your copyrighted work, but you would have to prove damages. If you get it registered through the US Copyright Office, then you don't have to prove that you own the work, and there are automatic damages when someone infringes on something that you own copyrighted federally. And the last thing that I will say here is once you get the official registration through the Trademark Office, you can use the R symbol with a circle around it. That means that you do have the official registration. And when you get the official copyright registration of a copyrighted work, you can use the C with the circle around it. Also, just be careful here that what you're selling online through digital products doesn't infringe on someone else's already copyrighted works or trademark rights. So what do I mean by this? If you're selling something on eBay or Etsy or through your e-commerce site, don't fall into the trap of using too much of a book or a movie or something that is obviously copyrighted by someone else. While this can fall under fair use, you don't want to get into a fair use legal battle. A good example of this is Harry Potter. If you're selling anything with Harry Potter on it, the chances of it getting taken down and you getting a demand letter are very high because J.K. Rowling did not allow you to use her trademark or her copyrighted materials. The same goes for Disney and sporting goods swag. If you didn't get permission from them to make a t-shirt and sell it online or to print out anything digitally, then they are probably going to get hit with a big fat lawsuit from these companies because you didn't have a license to do so. So my friend, yes, you can make the passive income of your dreams by selling digital products. But understanding these steps that I talked about today in this video is the key to protecting your business. And I know that you want to keep all of the aspects of your business legal, and that's why I've lined up this video that popped up here on this screen. It'll go through all of the legal documents that you need to have to protect your small business.